Yes, Mr. Lako.
My Lord, I wish to briefly respond to a few issues. Let me start with section 342A3C referred to by my learned friend, striking off this matter of the law. My Lord, this is a non-starter.
Why do you say that?
My learned friend concedes the unreasonable delay that is occasioned in these proceedings has got nothing to do with the state. The state is ready. My Lord, they are my files. We are ready to call a witness anytime now. I had hoped.
But there's one part, Mr. Laka, you need to take into account.
Yes.
Court takes into account. The history of this matter is not an isolated incident today that the accused is not here.
True.
There's been postponements before, and I've not heard you address me that any one of the accused from number 1 to number 4 requested postponement. And if the matter was postponed several times and they have not asked for that postponement, then they have been prejudiced. Now, that is the history that you need to take into account. And also of the fact that the prosecution is not willing to request a separation. Now, if the prosecution is not willing to request a separation, the question of 342A comes onto the table for consideration. That's why I say that I do not follow your submission when you say it's a non-starter.
My Lord, the first
now,
point.
That's all that is predicated on the assumption I don't uphold your application in terms of 159.
Another consideration should be you are having an application by accused number 5's legal representative for a postponement because the accused number 5 is not here. In other words, you've got to deal with that aspect and then deal with our application. Our application is not the first application before your Lordship.
Yes.
The first application, it's by accused number 5's legal representative that this matter be postponed. And interestingly, my two learned friend said nothing about that request of the postponement by accused number 5.
No, I thought I heard them address it in the course of their submissions that this matter has been postponed several times.
Yes.
And not in a position to can accede to any further postponement because of the prejudice. That's how I understood their argument.
They were just talking about the conduct of the legal representative, but not specifically responding to the application made.
You say that they are in support of an application for postponement.
I'm saying they did not express themselves against it. And
yes,
I'm saying that is application 1. My application to have the proceeding continued in the absence of accused number 5. It's the second.
Can I interrupt you? 1 minute. Sir, Mr. Policeman, at the back there, please keep that door closed. When the proceedings are on, nobody is to come out, to come in or out. Right. I'm sorry for that disturbance.
No problem, my Lord. What I'm saying is, my Lord, you have the first application, it's
for postponement.
Postponement.
Yes.
And we were saying, in the event your Lordship is not inclined to grant that postponement,
yes,
then let's continue in the absence of accused number 5. That is our point.
Yes.
Because the section is saying, in the event the court feels that it is not desirable to have a postponement. That is why we undergate that particular section. The first issue that your Lordship should deal with it's that application. Then our application to continue in the absence of accused number 5.
In that order.
In that order.
And if both fail, I have to go to the 342A.
No, that I said it's a non-starter.
Yes. Let's hear.
Your Lordship may differ with me, but in my submission, my Lord, you can only go there if Your Lordship accepts or at least attribute some part of or apportion some blame for this unreasonable delay. It has never been at the instance of the state that the matter was postponed. And therefore, the state should not be put into that particular situation.
Well, it's all parties are put in that situation, not only the state. If I strike the matter from the roll, it will mean that it gives the state the time to go and prepare in terms of making an inquiry about the fitness of number 5 to stand trial. And that should not hold back the other accused in terms of doing what they want to do. And everybody else will be accommodated in that order, except the court, of course.
Unless, Your Lordship, when you make that order, you specifically say you do not do so because you apportion any blame on the state. Because the state is ready. There are our boxes. We are ready to call the witness now. Except that my learned friends who are saying they want this matter to continue, they want their day in court, they oppose my calling my witness right away. Because if...
No, that's not their opposition. They don't oppose you calling witnesses.
They oppose me.
They oppose your application of 159 on the basis that, one, there's no precedent that would follow. If we are to go for 159, it means we proceed and accused number 5 is not here.
Yes.
Somewhere down the line, he has to come and join us and plead.
True.
I myself have been in private practice, as you know, and also here on the bench. I've never seen that procedure.
My Lord.
And that accused number 5, because none of us in this court, including his representative, can guarantee when number 5 will be here. And if he comes at the end of the trial, what happens? Is that the risk that we want to take? If he comes at the end of the trial, it means we have to start all over. And that will be prejudicial, not only to the accused, but to the witnesses as well. Because the witnesses will be called again to come and testify, the witnesses for the state. And I'm not sure whether that really is not a prejudice to them. Because I take it that when they come here, they've requested time from their work commitments every time this matter is postponed. And my understanding is that all the parties before me, the state as well as the defense, all of you are opposed to a postponement. Am I correct?
Yeah.
Yes. Now postponement is off the table. So let's look at 159, let's look at the application, including the application for postponement except number 5, and I will address it. But all other parties are opposed to postponement. So I have 159, I have 342A.
My Lord, the provision makes that procedure available to you. It may well be. It has never been applied, but the Constitution enjoins you, my Lord, to develop the jurisprudence. If it is in the Act, it has not been applied, it does not mean it's not law. Test it, my Lord. Take a lead. Take a lead. Develop this jurisprudence.
There is no problem with that. The problem is the consequences of that action you are prescribing.
It is not unlawful, my Lord.
No. I'm talking about the conduct of this trial. It will be nice to develop the law for the sake of developing it. But the conduct of this trial, and I've given you a scenario, which is one possible scenario that will emerge, that in the event the accused number 5 gets well 3, 4, or 5 weeks down the line, when we are about to round up the state's case, what do? You're going to put charges to him? We have to come back here again and start all over.
My Lord,
Because his legal representative will want to cross-examine the state witnesses. What do we do?
my Lord, I do not believe I can persuade you beyond this point.
Oh,
In the circumstances, I stand down.
No, you did your work. Before me, I have 3 applications. The first one is by accused number 5, legal representative. It is so that when the proceedings started yesterday, accused number 5 was absent, and he continues to be absent from the proceedings. We were handed in a certificate from the hospital stating that accused number 1 suffers from a major depression episode, and he has been given leave until the 21st of August 2015. Now, we are unable to make a determination as to at that date he will be in a position to attend trial or not. I don't have that evidence before me. And as counsel correctly pointed out, this will require that if this matter is postponed, an inquiry be conducted in terms of Section 67. And there's also no time frame that can accommodate that process, which will ensure that the accused who are present in court are not prejudiced. Now, the request for a postponement should be seen within the context of the history of this case. I was not involved in this case from the beginning, but from the submissions made, the arrests of the accused, I'm told, occurred around the 26th of September 2012. Since then, the accused have been standing trial in this matter. It's 2012, we are now moving into 2016. We are in the afternoon of 2015 as it stands. And I believe that that is too long. It's a delay too long for accused to be standing trial. And that one way or the other, their fate must be decided. Now, this absence of accused number 5 could be cured in one of the following ways. Any one of the following ways. Either we postpone, which is now out of the question because of the history of this matter, or the application made by the state that we should have the proceedings continue in terms of Section 159 in the absence of accused number 5, which I will allude to just now, or alternatively, that the state makes an application to separate the trial. Now, the application launched by the state that we should proceed to Section 159 is fraught with problems. And I will not venture into the various legal interpretations that are abound here, which could go one way or the other. I'm more concerned about the practical implementation of the process as we go forward. If I grant 159, it will mean that the accused number 5, at any stage of the proceedings, even towards the end of the proceedings, when judgment is about to be granted, may come forward and enter the proceedings. And that will throw us back to the beginning. It will be a waste of time. It will be prejudicial to the accused who are here. It will be unfair to the state witnesses. It will be unfair to their witnesses. It will be an inconvenience to this court, having set aside time for that, and obviously to the legal representatives. So the application in terms of postponement by accused number 5 is refused. And the application for the trial to continue in terms of Section 159 is equally refused. That leaves the application in terms of 342A Now, that section 342A reads as follows. I quote, "A court before which criminal proceedings are pending shall investigate any delay in the completion of proceedings which appears to the court to be unreasonable and which could cause substantial prejudice to the prosecution, the accused, or his or her legal advisor, the state, or a witness. In considering the question whether any delay is unreasonable, the court shall consider the following factors. A, the duration of the delay. B, the reasons advanced for the delay. C, whether any person can be blamed for the delay. And D, the effect of the delay on the personal circumstances of accused and witness. E, the seriousness, extent, and complexity of the charges or charge. And F, actual or potential prejudice caused by the state or the defense by the delay, including a weakening of the quality of evidence, the possible death or disappearance or non-availability of witnesses, the loss of evidence, problems regarding the gathering of evidence, and consideration of cost. E, the effect of the delay on the administration of justice. H, the adverse effect on the interest of the public on the victims in the event of the prosecution being stopped or discontinued. I, any other factor which in the opinion of the court ought to be taken into account. Now, clearly, there are a number of factors that speak to this case, which I've just read now. Firstly, the history of this case shows that there's been numerous postponements. And those postponements, part of them I was told, which Mr. Laga did not dispute, were occasioned by the state. Secondly, we have the conduct of accused number 5, who's not here. I'm informed that at the last sitting, the reason why this matter was postponed so long and to the date yesterday was because that came at the request of accused number 5's legal representative, who indicated his availability for the 3rd of August. Now, today, we have a similar problem from accused number 5. The factors that I consider to be of paramount is all parties tell me, except accused number 5, that they are ready to proceed with this trial. And I may mention that the court is also ready to proceed with this trial. But then we have this problem where accused number 5 is not present, and the state is not willing to make an application for separation of powers for reasons that they've advanced. And the court has no authority in terms of the act to make a mero moto ruling of separation of this trial. If the court had that authority, I certainly would have used it. I must make that clear. Because this trial needs to proceed. The accused need to know their fate one way or the other. But then the circumstances are such that the conduct of accused number 5 has not been very helpful in these proceedings. And for that reason, I will take a course that will be less prejudicial to all the parties involved. Firstly, the state will have to understand that the requests for postponement that they had raised earlier on have now caught up with us. If the trial had started then, we wouldn't be in this situation. Secondly, I have a sense that starting from 2012 up to 2015 is too long a time for any person to have a sword hanging over his head. And I'm not willing to subject the accused to that particular ordeal once more. And for that reason, the application in terms of Section 342A is granted. The case is struck from the roll, and the bail that has been paid by the accused will be refunded. The prosecution, when it's ready, it will then reconstitute the court and serve the indictments on the accused, when and should it want to do so. That is the order. Yes, you may be seated. I'm not continuing. Accused, what all this means is that you are now free to go. But you need to understand that because you have not pleaded to the charge, the state may decide to recharge you at a later stage. It may not. But for now, the case is over. You are free to go. We adjourn the proceedings.
All right. La